Well, hi there. Good afternoon, good morning to everybody joining us this afternoon if you're on the East Coast, or perhaps still the morning if you're in Alberta or BC. Thank you for tuning in. I am Sephton Leibbrandt, and this is a live Q&A for the next 30 minutes, and we are the employment lawyers. We'll be answering, of course, your questions about everything to do with employment law, severance packages, constructive terminations, straightforward terminations, temporary layoffs, even human rights issues and things like that. Any questions you may have about situations in your employment that are causing you some concern, feel free to pop a message into the chat box on whichever platform you happen to be joining us on, whether it be YouTube, LinkedIn, or something else other than that. And we're happy to answer them. Again, my name is Sephton Leibbrandt. I'm an associate at Samfiru, Tumarkin, LLP, and we are the employment lawyers. Happy to answer your questions here today. So thank you, everybody, for joining us this afternoon. While we wait for some questions to kind of roll in to the chat, one kind of topic I think that's at the top of everybody's mind these days, kind of get the ball rolling here, is Mr. Trump seems to be back to his old antics, once again, threatening us with these very significant and hostile tariffs. Now he's saying again that these tariffs are going to come in, on schedule on March the 4th of 2025. And, ultimately, of course, we'll see whether that ends up to be the case or not. One never knows with Mr. Trump what he elects to do. But if those, do come to pass, no question it will certainly have some very significant and unfortunately, detrimental effects to our economy and our jobs and industries and things like that. So it's very important, especially at this particular point in time, I believe, to know, what you should do, who you should reach out to in the event that your employment is either terminated in response to these layoffs simply because business is suffering to such a significant degree, or of course potentially you're placed on instead a temporary layoff, which means that the company may potentially recall you at some point in time in the future, but for the moment they're saying there's not enough work to keep you around, to keep you on board. So let's kind of start with the first one, what I'm just talking about here, temporary layoffs, being laid off, and what exactly the issues are there and what you should do. So the number one thing, of course, that you should do is, if you are placed on a temporary layoff, don't just kind of roll with it. Don't just accept it and keep on working, or of course just not of course continue to work, but make sure, of course, that you would reach out, right away about that temporary layoff to us at the firm here. You can reach us, of course, at employmentlawyer.ca. But the very important thing is, and the key thing is here, that you can't, let these things kind of, lay and rest and then say, well, maybe I'll deal with it in another month or a couple months or a few months. That's absolutely the wrong way to go about it, unfortunately. Simply because the fact is that the longer that the temporary layoff goes on and you don't say, anything about it to the employer, whether you accept it, whether you decline it, the employer, gains what's called an argument that you may have condoned or accepted the temporary layoff. So it's very, very important to reach out to an employment lawyer, right away as soon as you're placed on that temporary layoff, and we can get you, the answer to your question, which is, at the top of your mind is, am I entitled to a severance package? And, in the most part, in most cases, employees that have been placed on a temporary layoff, they are entitled to a severance package. And it can be, very, very significant depending on your age or years of service with the company, your position, whether you're management or not management. In almost, every case, a severance package is generally payable in those circumstances. Of course, we need to see, all the documents, the contract, if there is one, to make sure that that is exactly the case. But the long and the short of it is, don't let these things kind of lie. You need to act on it, sooner rather than later. Just putting it off, unfortunately, is not a good thing to do for your legal rights and interests. That's number one on those. With respect to, of course, ordinary terminations of employment, that's a little bit more simple. The same thing again, though, of course, regardless, you receive, of course, a severance package from the company. They offer some sort of offer to you. In the vast majority of the cases, what I see is that those severance packages simply aren't adequate. The amount that the employer is offered upon termination, more often than not, is substantially below an employee's minimum, not minimum, but employees in common law entitlements, so their general entitlements to a severance package. And the reason, of course, for that is that the company wants to get out with the best possible deal, the most favorable deal for them, and that's why they put the offer forward that they do. That's why it's very, very important to reach out to an employment lawyer like ourselves, and you can, of course, reach us at employmentlawyer.ca and get all our contact information there. And of course, if you're just curious about how much potentially you may be owed in a severance package, you can also just go and fill out our severance calculator. That's at pocketemploymentlawyer.ca, and just found out there, how much you potentially, may be owed in your severance package. But definitely, the key thing here is, just like with the temporary layoff, number one, don't just, kind of take it at face value. Don't accept it for what it is. Make sure you ask questions about the package that you've been offered. Is it sufficient? Is it insufficient? And in the most part of the times that I see, that those packages are not sufficient. They're not adequate. They're not enough. And you're owed more money, typically, than the company has offered you initially. And of course, like I mentioned, the interest of the company is simply just to get the most favorable deal, have you sign off on that release document, and then they're good to go forever, because as soon as you sign on that release, on that dotted line, and the most, in almost every single case, there's nothing further, unfortunately, that an employment lawyer or any lawyer can do for you in that circumstance. So, definitely reach out to us if you've been terminated, temporarily laid off. It's definitely something you want to get advice on right away. And of course, we're very happy to answer those kinds of questions at any time. We have people standing by all the time to get you in contact with the lawyer so that they can assess your matter and see exactly how much severance you may be entitled to in the particular circumstance you're in. So that's definitely something that everybody should keep in mind just at the outset here. Again, given these very, very uncertain times, unfortunately, when we're dealing with a rather hostile and unfriendly government in our closest ally and neighbor. So I'm seeing some questions popping into the chat now, which is excellent. Looks like our first question is from World Boss on YouTube. He says that he's been with the company for 10 years now. They put him on a temporary layoff. Is this legal, and how can I go about getting a package? So in most of the circumstances, World Boss, it's not legal to place somebody on a temporary layoff. There's no inherent right, so you understand, legally to place somebody on a temporary layoff. A lot of it will depend on the terms of your contract of employment with the company, if you have a written contract, and what that contract says about whether the company has that right to do that. That's the first thing to look at right there. It also kind of depends how long you've been on the layoff for. If you've been on the layoff now for 35 weeks, for instance, then even under the legislation, you're considered to be terminated at this point. If it's less than 35 weeks and they're continuing your benefits, or you're on EI, for instance, still, then under the legislation, you may still be technically employed, but ultimately, that doesn't matter either way if they don't have a contract that expressly permits them to place you on that temporary layoff. So it sounds like you should definitely reach out to us at employmentlawyer.ca. And speak with one of our lawyers so that we can give you the full assessment of your particular matter and circumstances, and make sure, if you are entitled to a severance package, after 10 years, it could be, quite significant. And that's, a lot of years of service with the company of a single employer. So definitely reach out to us, please. And we're definitely happy to answer and assess that situation a little bit further. But, shorter answer of it, of course, is, no, it's not illegal in most circumstances, and you may be entitled very well to a severance package of a significant size. So please reach out to us about that, and I appreciate your question. Moving on, another question here, another from YouTube as well. Looks like Ingalls from YouTube. Hopefully I'm pronouncing that correctly. It says, what do you think the impact will be on Canadian workers for US-based companies? Can they just let us all go? Well, a lot of it, of course, will depend, Ingalls, on the industry that you're in. Is it one of these industries that will be affected by tariffs? If that's the case, then ultimately, if you're working in Canada, you're working especially in Ontario, for instance, or BC and Alberta, where our offices are based. In those provinces, no question about it, you will be entitled to a severance package of some nature. Be first entitled to the minimum entitlements in that particular province of that you reside in. If it's Ontario, for instance, then the ESA will govern your bare minimum entitlements. But of course, regardless of where you reside in Canada, as long as you do in fact reside in Canada and work for this U.S. company, then you will be entitled to what's called a severance package at common law, which is the greatest possible amount of severance that one can receive, from a legal perspective. And so, they would have to provide you that kind of a severance package, and that's what you'd be entitled to at your termination there. So, definitely with U.S. companies, especially, they often have, in my experience, a poor understanding of, Canadian employment laws, and especially the provincial laws and things like that. And, their contracts often aren't up to snuff. So, in those particular circumstances, you definitely want to, take a close look at, what you've been offered by the employer, and definitely reach out to us at employmentlawyer.ca and get that package, assessed for you if you, unfortunately end up, being terminated or temporarily laid off, as a result of these incoming tariffs. Yeah, it's just, in the circumstances, again, those U.S. companies, they are, they're really not used to, the extent of the severance packages that are owed and payable in Canada on terminations. A lot of U.S. States, for instance, have something called employment at will, which basically means you get $0.000 if you're terminated for any reason whatsoever, which is of course completely different than what happens here in Ontario and in Canada. Of course, here you're entitled to typically a very significant severance package, potentially up to 2 years of severance, if you're terminated, and the right kind of factors apply in your circumstances. So definitely, if the unfortunate circumstance comes to pass, I hope it absolutely does not, and I hope Mr. Trump here is just being a braggart, as he often is, and just trying to get attention, as he often does. But if that does come to pass, please absolutely reach out to us about your situation. Get us to look at your severance package. Make sure it's actually a fair severance package, because, as I said, in my experience with U.S. companies, more oftentimes than not, the severance packages are worse than the Canadian companies, because they just don't have the same kind of appreciation, understanding of our laws here in Canada, and especially how favorable they are in Ontario, for instance, in Alberta and BC. So thank you very much, Ingalls, for your question there. We have some more questions rolling in here, which is great. Once again, I'm Sephton Leibbrandt. I'm an associate at Samfiru Tumarkin LLP, and this is the employment Q&A, 30-minute Q&A this afternoon. Thank you for everybody joining us here. We're answering, of course, all your questions about concerns regarding your employment and things of that nature, termination, severance packages, human rights concerns potentially, and things like that. Any questions about issues happening with your employment. So thank you again, everybody, for joining us this afternoon. So some other questions coming in here as well. I'm going to jump to in just a second after I get a drink of water. Very good. Okay. So YouTube, it looks like Ellie from YouTube writes us here. What if an employer claims they need to lay off staff off, but use this all as an opportunity to get rid of people they don't like? Is that a wrongful dismissal? So it's a good question, Ellie, an interesting question. So you understand, basically anything in Canada is a wrongful dismissal, as long as the company doesn't provide you an adequate severance package. So, in any circumstance where you've not been provided an adequate severance package, let's say, you're owed, 12 months of notice at law, and the company has offered you, 6 months of notice, that is a wrongful dismissal. That's what it is. It's all about just simply, is your severance package legally adequate or is it not? As soon as it's not legally adequate, you've been wrongfully dismissed. Doesn't matter, the reason or the rhyme or what's going on behind the scenes there. It's just about your severance package being adequate or not. And I get that question all the time. Is there this other separate thing about a wrongful dismissal if there's this reason or that reason? And it's a very good question, Ellie, because they're all wrongful dismissals. To put it very simply. So I know that's not your whole question. I know probably exactly what you're asking, but just to kind of to start off there, I'll just mention that. But with what your question is actually asking you, so as you understand, in Canada, Ontario, for instance, Alberta and BC, you don't need actually any kind of reason or rationale to terminate someone's employment. The caveat being that they need to provide you with an adequate severance package that reflects your legal entitlements and common law. And of course, what that means is that it's a severance package that looks at, number one, your length of service with the company, number two, your age, and number three, typically, your position with the company. Are you management? What's the nature of your position there? And then, of course, there's other factors as well, like rate of pay and availability of employment in your industry and things like that. But the three primary ones, of course, are your age, your years of service, and your position at the company. So, as I mentioned, they don't need any particular reason, unfortunately, to terminate you. If they don't like you, if they do like you, whatever it is, you can be terminated. It simply just means that they need to provide you with an adequate severance package at common law. If they don't do so, as I previously explained there, you've been wrongfully terminated, and it's as simple as that. If the package, you're owed 12 months, like I said, they provide you 6 or 8 or 10, it's a wrongful dismissal simply for that reason. They've not provided you a long enough notice period at common law, and the notice period, to understand, is the purpose of that is to allow you to find another comparable job. And that's what the purpose of the severance package is, to allow you to get enough time to find another comparable job. So hopefully that helps to answer your question, Ellie. And I thank you for that question. It's a very useful question, and one that I receive all the time about what exactly is a wrongful dismissal? Does it have anything specific or particular or special about it? It's not. It's just a general term used to describe any circumstance where the employee has not received an adequate severance package that's in line with their legal entitlements. So I really appreciate that question. A great one. Other questions rolling in now, which is great. Looks like another question from DW on YouTube. DW asks, how hard is it to prove ageism and what would constitute it? So, it can be difficult, of course, to prove anything where it's credibility based to some degree. If there's correspondence, for instance, between yourself, so emails, letters, whatever, text messages, anything, between yourself and the employer's making, comments offhand, like, you really seem to be slowing down here, or you just don't seem up to snuff anymore, like things of that nature. That would be a very strong case of ageism, potentially, depending on how much information you do have in that respect. Things that incline one to believe that your termination or your treatment is being again there's a connection with your age there. That is what you're really looking for. So it's hard to prove if things, of course, aren't in writing. So, number one, if you're concerned about ageism or any kind of discrimination, to the best of your possibility, try to get that information written down in some way, in an email, in a text message, so that you can have a lawyer rely upon later for you. And as I mentioned there before, in terms of what would constitute it, it's exactly kind of that correspondence, things, offhanded remarks about maybe your physical condition, your mental capacity, other things, about how quickly you're doing your job, or things of that nature, things that would, just generally commonsensically incline one to believe that, okay, well, this is saying something about my age here. Like I'm 65 or something like that. I'm 64, whatever it is. And this really seems to be kind of a pointed remark about my age, my health, and things like that. That's what again, it's not difficult to kind of determine if that's what kind of the implication that the employer is making. But the hard part, of course, is again, having the evidence to prove it. And the best thing to do, I guess, as I mentioned, in any type of circumstance where you're concerned about discrimination, whether it be ageism or something else, is to get it written down to the best of your ability. Put the correspondence, put the information in an email and a text message. Have the employer respond to you that way. Otherwise, it just becomes quite difficult if it's just your word against the employer's word, simply because, again, you don't have anything to point to when it comes to, for instance, dealing with the matter from a legal perspective, to tell, the other person's lawyer, like, look, I mean, they said this on this date, and you can point right to the email where they said it. I mean, and it's just, of course, when you have that, you have everything, right? You have all the leverage. If you don't have that, you're simply saying, well, my client says this happened on this or that date. It just becomes so much more difficult. And of course, the other lawyer is less concerned about, oh, do I really need to be worried about this right now? Because can they really prove it? And if they can prove it, it's going to take a long time to get there, rather than they have it in an email or a text message, and they've said this or that remark that looks awful. The optics of it are awful, and that really is what in my experience, inclines other defense lawyers, the lawyers for the employer, to really take a pause, take a step back, and think twice about how they deal with the matter going forward, because it's that kind of evidence that is not exactly, it's it's never the smoking gun in most cases, but it can be enough, right? All you need to do is it to be enough to kind of to make them worried, make them concerned about the situation. So that's hopefully of some help to you, DW. Again, it's the key is get it in writing to the best of your possible ability, and that way you can rely on it later. And when you have that written record, it just makes things so much more simple than it otherwise is to deal with the discrimination types of cases and issues. So thank you for that question, a really useful one for everybody listening. Some other questions rolling in here, which is great. So I see, let's say Reg from YouTube says that his wife had a difficult mat leave. Employer is claiming that she is past her required return date and has effectively resigned. She sent them doctor's note to say that she needed more time. Can they do this? No, so that's, it sounds like a big issue there, Reg. From a human rights perspective, of course, under the ESA, there's a certain amount of time that one has for a mat leave, but of course, the human rights legislation also says you can't treat somebody differently because of their maternity status, their family status, and things of that nature. And so they have an obligation, of course, there to accommodate to the point of undue hardship. So unless they can prove that your wife not returning at a particular date is actually meeting the threshold of what's called undue hardship, which is a very high threshold to meet. In most circumstances, it can't be met if the company is even somewhat of a bit of a not a large company, but as long as it's more than a few people, probably it would be very hard to meet that threshold. So number one, if she has a doctor's note that she provided to them, that's excellent, that's perfect. alleging that it's a resignation, that's a big issue. I mean, it's, unless your wife has said to them, that she resigns, you can't ever, imply a resignation. It needs to be what's called express and unequivocal. And in this particular circumstance, it doesn't seem like that's the case. It sounds like they've just, she's not been able to come back yet, and they've just assumed she's resigned. So this is definitely something you want to reach out to us about, or at least have her actually reach out to us about, and have her, our lawyers, our team here, assess your matter and assess your case here, because it sounds like there's a bunch of big red flags popping up for me looking at this, brief question you posed here. But yeah, the short end, the sweet of it is, sounds like this is an issue. Sounds like this is, potentially a contravention of the Ontario Human Rights Code in this particular case, and that your wife may have been constructively terminated if they're taking this resignation position, because it seems to have, no basis in law whatsoever. They have to accommodate to the point of undue hardship. Doesn't seem like to me, just generally that they'd probably be able to meet that threshold. And she needs to be returned to either her previous job with the company, or a comparable job. So this nonsense about, resigning because she didn't return by her exact date, it sounds like there's a number of issues there. So please reach out to us, employmentlawyer.ca. We can get you some more, particular help and assistance on your matter and get a more thorough assessment of what exactly is happening here in terms of, timelines and responses and communication between your wife and the company and things like that. But, on its face here, it sounds like there's a big issue. So thank you for reaching out about that. And, please reach out to our firm there to get, more in-depth assessment. We're getting, short in time here, folks. So I'm going to try to get to the next few questions here, and then we'll call it for the day. So looks like YouTube malicious, I think. I've been messing that up entirely. I'll say Mel, from YouTube, if your employer demotes you to a lower position but doesn't change your salary, is there anything that can be done? So typically that would, constitute a constructive termination, Mel. We need to look, of course, at the difference between the position. Is it truly a demotion or not? For instance, like a very clear example of demotion in your situation would be if you were a manager, for instance, with direct reports, and the company says, now you're not a manager anymore and you have no direct reports. That would be the most plain and obvious circumstance where that would in fact be a termination, a constructive termination of your employment. It doesn't matter that your salary is the same, your hours may be the same, location of work may be the same, everything may be the same, but a change of that, significant degree, that material degree that I just explained there, that is absolutely no question about it every day of the week, in my view, a constructive termination of, an employment relationship and a severance package flowing, from that, owing from that, constructive termination. So, please, reach out again to our firm to get, again, a more thorough assessment of what exactly has gone on here, and see if, kind of a severance package may be, owing to you. Again, you can see the little pop-up there at the bottom of your screen, employmentlawyer.ca. But that's definitely one we'll need to make, to have a better sense of the nature of the demotion. And is it really a demotion, or have they just kind of changed your title a little bit or something like that? It really needs to be, a material and significant change. And basically, so you understand, a constructive termination, it effectively means that the employment relationship as it was is now entirely different and cannot continue because it's now entirely different. So for instance, reducing somebody's pay by 20%, no question, that's a constructive termination of your employment. And in your case, again, change, demotion of one's position, very clearest and most simple one is, management to non-management. So we really need to determine there, is it, something as serious as that, where you were a manager and now you're not a manager, or is it something else that really, looks like it's, it is a constructive termination. It's, it's not, it's much, kind of, it's not exactly black and white. In many circumstances, we really need to look at the particular circumstances of your matter. So please reach out to us, and our team would be very happy to assist you and get some further answers on that. Looks like we're almost out of time here, and I think that was almost all the questions we had for today. Looks like it. Well, that's excellent. Thank you, everybody, for joining us this afternoon. Once again, I am Sephton Leibbrandt. I'm an associate at Samfiru Tumarkin LLP. Hopefully, you enjoyed today's session and provide some helpful information for everybody who tuned in. For those of you, of course, who did tune in, thank you very much for supporting us in that respect and for coming on and having your questions, asked and answered. That's what we, of course, strive to do here. Please, if you, again, how support what we do here on this 30-minute Q&A that we hold quite regularly. Please like and subscribe on whatever platform you may be on. We'll also be of course reconvening tomorrow with our managing partner, co-founding partner, Lior Samfiru, who'll be on tomorrow at 1 p.m. in the afternoon. So thank you for everybody joining us again this afternoon or in the morning if you're in BC, Alberta. It's been a pleasure. Take care now.